both types are public, so the entire public may use both Class 5 and Class 6 roads. The big difference is that the municipality is only obligated to maintain Class 5 roads.
Okay.
The municipality is not obligated to maintain Class 6 roads. That's the big difference.
Meet our guest, Paul Alfano. He is a Concord, New Hampshire real estate attorney with more than 40 years in specializing in complex property easement issues, boundary disputes. Believe me, in this business, I see it all. He also, which is interesting, is recognized authority on the New Hampshire road laws. In New Hampshire, you have Class 6, Class 5 roads. You have all kinds of issues of maintaining it, and he knows how to do that. So anyway, and he was previously served as a legal counsel to the New Hampshire State Senate. Welcome, Paul Alfano. I sold a house that had 4 houses on it. Class 6 road, there was no agreement between anybody. And so what I had to do is generate a road maintenance agreement that everybody would have to sign. Now, everyone, for some reason, still had the road plowed and whatever, but there was nothing in writing. Is it a problem with title not to have that?
No, it's not a title issue at all. It's a market-driven issue. Some people, anyway, that's just the short answer. It's not a title issue at all, but it certainly may affect a transaction. For example, you mentioned lenders. If a lender may want to see that, it'll affect market value. So I would say it's a market value issue rather than a title issue. In fact, it's interesting. What I've learned over time is I always lived on a town maintained road, and I like that. I don't want to be. No, actually, that's not true. I did live for a time on a road where it was shared maintenance, but a lot of people I've learned in New Hampshire like being on a private road. But the issue is the maintenance. And we get calls all the time to step into situations where you've got 10 owners and 2 refuse to pay, that sort of thing.
I think in Moultonborough, they have a situation where the town will plow a Class 6 road as long as there's a maintenance agreement. Whereas most towns, I had a house in Northwood, it was a private road, but we had our own plow guy. So, the money was collected for him. And then there's people who don't want to pay because they said the association was over 20 years old and it wasn't valid anymore. And I don't know if there's anything about that's true, or is it a road by road situation, HOA situation?
It's a road by road, HOA by HOA situation. It could be. I've never heard of something just expiring through the passage of time unless the agreement, the covenants, had an expiration date. I've seen that. We have for some reason that there's an expiration date. So I suspect that was that situation, that there was an agreement in place, but it had a term. Otherwise, absent something like that, the maintenance, if there's an obligation to maintain, and it would have to be an agreement or by the statute, it wouldn't go away simply by the mere passage of time, unless there was something in writing that said that. So I suspect that was, I'm guessing, the situation there.
Well, I think it was a combination. The association was 40 years old. There was a time frame. I think a lot of people can't get past the first 3 letters of association. And as time goes by, I think, is it your experience that a lot of associations are created because you need to have an association to have a road maintenance agreement before it becomes a town?
Well, interesting you should say that. I would say the short answer is probably no. It's probably that because if you're already on a road and a private road, and let's say there are 10 homes, and you're running into maintenance issues and you contact a lawyer or you try to come up with your own agreement, that's like worst case scenario. Now you got to pick up the pieces. You got to put something in place where nothing exists. And that certainly does happen. I think, if I understand your question correctly, if there's an association, I think it's more likely than not that it exists because it was created at the inception of the subdivision. And most well-structured subdivisions, the bigger ones, generally will have, although I shouldn't say that either. We see it all. We've seen gigantic ones, 200 lots where there's no agreement, and they've managed. And anyway,
So I'll go back. I think initially if you're designing a subdivision, you just have a bunch of paper roads. Do you need to have some sort of road maintenance agreement in place before you can start even making the roads? And then the town has to approve that
probably, yeah, you probably won't get subdivision approval
without it.
Yeah.
Okay. Now, I see the notes that you deal with a lot with the road issues and things like that, and easements and whatnot. What is your main focus of what you like to do? There's what you like to do, and there's what you end up doing.
I do the roads is such a niche that I enjoy all of it because and the issues we deal with are, is it a class 6 road? Is it a private road? Is it public or private? Is it class 6 versus class 5? And then when it comes to easements, whether one exists, what the scope of the easement is. So I actually enjoy, I'll answer your question. I do have a more specific answer to your question. But all of those I find interesting because it deals with the common law primarily, particularly easements. And I tell people this and they're sometimes surprised, particularly if you're in real estate and you're accustomed to wading through zoning ordinances, subdivision regulations, even brokers, right? You've got your listing agreements and you got all of these documents. And then from a municipal standpoint, as I started saying, you've got zoning ordinances, subdivision regulations, site plan regulations, driveway permit regulations, building codes. I mean, we're talking like a serious, if you printed it, pile of documents. But when it comes to easements, there's none. There's virtually no state statute. There's one that I can think of, but really it's all up to the courts. And for over 200 years, these disputes and what an easement means, what the scope of the easement, who has what right to use it, has been resolved by the courts. So I find that, and that's called the common law, and I find that interesting. But the part that I really enjoy, and you can't see it here because I don't have any, but we do have lots of maps around the office that we actually use as exhibits in trial. But I do the older roads, from at least 100 years ago, or probably older. We have a huge inventory of maps and other resources, town histories, things like that we've accumulated over the decades. And it's fun going back in time, so to speak, to see what the world was like at a particular time. Because when let's say an easement was created in 1843, we have a case now, just like that. It was created in 1843. The question is, what is the scope of the easement? What can you do with it? And the answer is, what the courts require is that you got to go back to the beginning and you got to try to figure out what was the intent at the time the easement was created. That's step one. And then you bring it forward because it's technology changes and it's understood, and the courts are tolerant that through economic development, lots will be subdivided and that sort of thing. But you got to go through that whole analysis. So I enjoy the old maps, the old town histories, old records. I particularly enjoy that part of it.
So some of the things I've run into. And do you handle title insurance for clients?
No.
Not really. Okay.
No. But I used to. So if you have a question, I understand how it works. I used to issue lots of policies, but I don't do that now.
Now I do a lot of waterfront properties, and of course there's all kinds of things that happens with that. I know of a case where a very wealthy person bought a piece of land next to what was a supposed shared easement for a bunch of neighbors. He decided he's putting up a fence. And then he decided, that's mine. And he was a big time attorney, he had lots of money, and it was a hard thing to deal with because you have all these people that said, wait a minute, that's been our easement to the lake forever. I would think that's like a case you might handle because it goes back in history.
Absolutely. We handle those sorts of cases all the time. We have, I think, 7 lawyers in the office and several paralegals, and we're busy doing exactly that sort of thing. And it's interesting, too, you mentioned the waterfront. What I've noticed is if the easement relates to the waterfront, that's like a different category. People will fight, and a lot of them have the money. So there's that component. There's this old saying that litigation is the rich person's entertainment. It's not for most people, but for some people, I think it might be who have really a lot of money, and they also tend to have, if they're going to have a vacation property, it'll be by the water. So people will fight really hard, I find, when it's by the water. So what you described is something we deal with all the time. So what we're working on, because we handle so many of them, is to try to, and we've gotten really good at streamlining the process, get the title work done. And the way I try to design things is we're preparing for trial right from the beginning, because you can waste a lot of time hoping the case will get settled and going back and forth. And sometimes you're better, particularly if it's egregious. And what you described, and we've seen that, it's funny. It's almost like there's 10 templates, but one is you got the wealthy out of stater usually because they're not familiar with maybe New Hampshire, and they come in and they read just their title policy, or maybe they don't even read the title policy. They don't read the easements, or maybe the easement got missed too. That happens a lot too. Just because an easement is not included in the latest deed. In fact, that's the one statute. I was talking about how there's no statutes dealing with easements, but there is one. And that one statute does say that even though a current deed may conveniently omit an easement, it doesn't mean that it automatically goes away. So that happens sometimes too. And there I understand why people may have missed it, because with title insurance, you're only obligated to go back so far, 35 years to a warranty deed. And so some of these easements could be 100 years old, but they very well may still exist, but you wouldn't catch it if a couple of grantors started dropping it from from the descriptions. But usually it's more, they are aware of it and they're just muscling their way into the neighborhood.
I'll give you some other examples that have happened to me. I've been in the business for 20 years, so that's being in the business for 50 years, I think. But I had one situation where my buyer was buying 2 parcels. One was, it was like a little tiny island in a cove, and especially on Lake Winnipesaukee, it gets whatever. And you get title insurance, and I always tell people you got to get title insurance. And so they bought it, and the neighbor across the cove, so there's a cove of water, claimed that half of that little island was theirs because they always used it. $400,000 in litigation, which of course is what you have title insurance for. He lost, but he was just trying to get it. But it went back. They had to have witnesses from the Boy Scout camp that used to be there, all kinds of stuff. But it's just a headache. In that case, they lost, but it took a year, and you can't list a property that has litigation going as well. So it affects everybody in there. Then we found out that the previous owner sold because that same guy did the same thing and it wasn't disclosed. So now his title company is involved. It got just really messy in that kind of regard. And then even with deeds, I sold a property that had 5 since 1934. And what had happened is the land under the house had never been transferred. Now, the title company, who I always recommend, fixed it, but that was years and years of fixing the whole thing with how the land wasn't included in the 5 transactions. And they had a road situation, which would have probably involved you. It was a private road situation, and it wasn't determined where even the road was. So it's all kinds of, maybe when you go back to your pile of maps, you probably have it, right? You collect maps, right? I collect lakes, you collect maps. The difference is that you can put the maps in your office. I can't do anything with the lakes. they just stay where they are. But
Sure, but you can go out to the lakes.
I can go out to the lakes, but I've also run into a lot of serious situations with lakes. Like Bow Lake has all kinds of things that there's a road there was a development made with promises that everyone gets a dock, and I don't know if so everyone on the road gets the dock. They didn't have enough approvals for a dock for everybody, so then it became, how do you get a dock? And there were 2 houses of the 10 that had a deeded dock slip one side. But it didn't change. The president of the association said, when that house sells, then I get it. So then that just becomes a blurry mess. And I've run into a development, actually a road that I used to live in Northwood. The original surveyor, I'm told, had a little problem with, he had a liquid lunch and dinner every day. And so a lot of his markers were a little blurred. And so I can imagine you got to resurvey the whole thing, but you have to go back. In that case, it was developed in 1962, and it was a logging road. I don't know what you do with logging roads that turn into roads. And so I've just seen messes like that all the time. Now, just for our audience, what's the difference between a Class 6 and a Class 5 road? A public road is pretty obvious.
Both types are public, so the entire public may use both Class 5 and Class 6 roads. The big difference is that the municipality is only obligated to maintain Class 5 roads.
Okay.
The municipality is not obligated to maintain Class 6 roads. That's the big difference.
But now I see towns on a Class 6 road require the residents to sign something, a waiver for applying for like ambulances and fire trucks, like that.
Yep, that is true. And there was a law passed last year to simplify the building permit process, but it's true. It's been this way for many decades that there's a state statute that says if you want to build on a lot, the road providing access to the lot must be Class 5. Period. Yep. However, if you're on a private road or a Class 6 road, then, well, it's a little different now, which I can explain. There are different effective dates, and one of the bills is under attack. But one of the changes that was made last year is under attack in the legislature right now, which is right across the street from my office, the State House. But you do need generally some sort of approval from the municipality. And it's the Board of Selectmen who grants that approval. And you do have to record, the statute requires the recording of a document, which basically says a couple of things. One is that you acknowledge that the town is not obligated to maintain the road, and you'll hold the town harmless from liability if someone gets hurt on this non-maintained road. And then towns will sometimes try to stick in other things. I won't get into that, but we've had some issues with towns where they try to load in additional requirements because in a way people are very much, it's either get your building permit and agree to this or not. So there were some efforts last year to ease that. And it was very, very helpful. If you're on a Class 6 road, as the law stands now, beginning in July of 2026, you could pretty much just go in and get your building permit provided you sign that. There's no approval really technically required by the Board of Selectmen, whereas the prior law said that you need both the approval of the selectmen and you've got to record this document that you referenced. And so the idea behind the legislation was to remove the select board part, because I've run into countless situations like that. There are no rules that govern the select board's decision. And I encountered at least one town where the town administrator proudly told me that they've never issued a building permit on a Class 6 road. And they basically have no intention of ever doing it again, so go away. Now, that's not right, and it's actually short-sighted, because all these lots that are access by class 6 roads cannot be developed and added to the tax rolls, et cetera, et cetera. But so what the town would want you to do is, sure, you can develop your lot, but you got to bring it up to current town specs and make it a class 5 road, which is very expensive.
From my experience, it will eliminate a whole bunch of waterfront properties.
Absolutely.
Because very few are on a class 5 paved public road. Now, the other thing is that, so again, a house that I lived in Northwood, it was 2 miles long. It was a logging road. It was opened in 1962. And then a lot of things changed. Somehow all lots now have to be 2 acres. They're all half-acre lots. But then newer developments, and I don't know if this is a general rule or just what towns like to say, is they don't want a road to be more than 1,000 feet with a cul-de-sac with a turnaround at the end, and it's because of ambulances and fire trucks. And certainly one thing on my road, if a fire truck came down the road, they would have to go to the end before they could turn around to go back, because it's a narrow thing. So it seems like that's where I start seeing things like the town issuing letters every year that you have to sign. I guess it's protecting them, waiving any, holding them harmless of a situation like that. Does that sound?
I'm not familiar with the annual letter thing, and
It's just Northwood that I know of.
Oh.
But it was more of, it seemed like it was primarily for holding the town harmless of a situation like that. I mean, you have to maintain your road, but you get this big honking fire truck. But then again, Home Depot can always find a way to get down to your house.
sure. Yeah, the increasing size of municipal vehicles I've seen as it plays out all kinds of probably unforeseen consequences. One being that roads get widened over time, and particularly as they're making turns, we've had cases like that where over time the road just gets wider. In fact, the road is not getting wider, but the town says it is. But
trucks are getting wider.
What's that?
Because the trucks are getting wider.
Yes. Yeah. And they're becoming less. So that's what it comes down to. That's really the point I just wanted to make. Because the trucks are getting bigger, that it's harder for them to plow these older, narrower roads. So I'm not sure. But at Northwood, the 1,000 feet, I have seen that where towns have, if it's a non-town maintained road, they'll also they'll have an arbitrary limit. Like I've seen 600 feet for some reason a lot, where the town will say, listen, we'll give you a building permit on your class 6 road, but the road can't be longer than 600 feet. Arbitrary things like that, which I think are a problem, because you can have a really good road that's 2,000 feet and a pretty crummy road that's 100 feet. That's more dangerous for the truck, let's say. But those are some of the problems you get into when things are left arbitrary. You get these weird policies that don't necessarily match reality.
So I probably maybe see this more on someone buys a lot and they have a designer come and figure out they can have 7 lots, but they don't go to the town to see that you could really only have 4 lots, or you could have a shared driveway, but then you're limited to 1,000 feet or something like that. And every town, it seems, have different rules about how many people could be on a shared driveway. Some are 2 lots, 3 lots, whatever, and that impacts the cost. Do you get involved with the development stage of?
Oh yeah, sure. What we do is, you raise a really good point about doing your due diligence. If you want to develop something, do your due diligence before you buy it, particularly if you're making the financial calculations based on an assumption that you'll get a certain number of lots. What we do is, 'cause we could do that, but it would be expensive to have lawyers combing through the ordinances. So what we do is we'll suggest that they engage a civil engineer with experience in that municipality. And there's lots of them who appear before towns all the time, and they have all that information at their fingertips. That's probably the most cost-effective way to do it. Plus, of course, that same person could be the one that would be designing your subdivision. So I would say you don't need a lawyer for that, but you definitely should do your due diligence. And I think the best, most cost-effective route is to just get a land surveyor or civil engineer to do that.
I've seen a situation where a driveway was started in one town and went into the next, and both towns have totally different rules about what a road should be, and so it was almost impossible to get any approvals.
Yeah, that is a problem. I don't have an easy solution to that. There's no overriding state law. There's some state laws when it comes to the creation of public highways or public roads that deal with that. But what you're describing, yeah, it can be. Yeah, we've got at least one that comes to the top of my mind right now in the office now that soon will be coming to litigation. That's like that. But you're right. It is what it is. It is complicated. You do have to likely get approvals from both towns.
I've seen another situation in Hampton, multi-million-dollar homes on Boar's Head, so it's a little tiny road. And after the closing, they found out that there was, because it was allowed that the yard went into what was technically the town road. Of course, the town road is what, 25 feet from the center or something like that. And it was required a few sales ago to have $1 million policy to hold the town harmless. Nobody knew about it, and that's a public road. And I'm not sure how that even came to be to begin with. The town that did that.
That's unusual. But it does get to an important area of confusion that people have, is they equate the road oftentimes with the paved road that they see. But in fact, and you were alluding to this, in fact, it's usually twice that. 3 rods, which is 49.5 feet, or call it 50 feet, is a common width of the road, but that's the public and the municipality has the right to work within that 50 feet, but the actual paved portion is maybe 20 or 25 feet. And the additional land is for drainage and pile snow and things like that. And people have the right to use, let's say it's the non-paved area. People, that's a whole another gray area. People are presumed to own to the middle of the road, subject to the rights of the public to use the road. That's another huge area that we deal with a lot. And so sometimes we'll have fights over trees and things like that are in the area between the paved road and the edge of the actual municipal right of way.
So now I live on Center Street, which is Route 28, technically, in Wolfboro. And I asked the question, can I put a fence up? And a lot of people may not go through the process if they put up their own fence to figure out where that is. In my case, I found out it was 32 feet from the middle before you could do it. But now let's say you're in a town and there's a sidewalk, let's say Rochester. It's all sidewalks. They maintain it, but you have to maintain it as well in terms of snow and that kind of stuff in front of your house, like going the steps up, but it's not your land. So if there's a lawsuit, it's not really technically your land, but
if it's not your land, then you don't have to do anything. I think what's probably the situation there in Rochester is that the people probably own to the middle of the road. It's somewhat rare. I'm not sure how Rochester does it, but it's somewhat rare for towns to get deeds for roads. Some of them do. Some towns, through their legal counsel I've just from dealing with them over the decades, advise their towns to get deeds. So then in that case, the town would own it. So that's question number one, Mike, is who owns that land? If you don't, if it was actually it was either conveyed to the municipality at some point, or there is a way that a municipality can lay out or create a highway and actually take title to the land as well. And that middle of the road presumption would not apply. If that's the situation there, then you have no obligation whatsoever. You don't own the land. And I don't see how a municipality could obligate you, a private citizen, to maintain public land. So I have a feeling that's that. But if you own to the middle of the road, but I still don't see how they can require you to. They can try it and maybe they get away with it. But if it's see, the issue is the concept is, if something is public, it's, in my view. And again, we run into all these issues all the time, and some of them are unresolved, meaning there's no Supreme Court decision that answers the question. But we run into it all the time where a municipality, let's say your sidewalk situation, they may have an ordinance that says you have to maintain the sidewalk in front of your house. I don't know. I question whether that's constitutional if it's private property, number one, because what they're telling you is this is a public asset. This is a sidewalk for the public to use. And we're telling you, private citizen, you have to maintain it. I question that.
I guess I see with selling so many houses, especially with out of town people, they want to know where their boundaries are. Okay. Now, I would say that I've seen more that your property line is technically like 25 feet from the middle of the road, not to the middle of the road. So then you have that. However, you're utilizing the space between the end of the pavement and your yard or wherever the line is. And from a liability standpoint, if somebody falls in that space, who's liable for that? Is that like town to town, and how do you even know? I don't see anywhere that I can see from deeds. You can see meets and bounds, but that doesn't mean you know exactly where they are.
And here's the big strangeness. We had a case just 2 years ago where the Superior Court just didn't. It's ultimately up to us as lawyers to be clear and convincing when we make an argument, but the Supreme Court fixed it. But like the deed to your property, if you look at it and it says running along the road 200 feet to a point, blah, 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 or it says fence running along Jones Road to a point, something like that, there's a presumption. So you look at that, you'd say, okay, I only own what's inside that description. I don't own any of the road. The reality is, though, in most cases, you technically own the fee to the middle of the road. So it's a longstanding presumption in New Hampshire law that if you have a legal description that runs along a road, you not only own your lot, but you also own to the middle of the road. Now that's a strange concept. In title insurance policies, of course, the legal description is just what's in the deed and all that, and nobody thinks about it. But this gets to your question then, is from liability. From a zoning standpoint, they use the edge of the right of way, even though you may own some of it. For all sorts of reasons, the people ignore the fact that the lot actually may include to the middle of the road. And part of the reason is it's so heavily encumbered by this right of the municipality to do what they want effectively that relates to travel within that. So when it comes to liability, I think anytime you cause an injury, then you're probably liable no matter what. And we don't do personal injury work in our office, so it's not my strong suit, the subtleties of that. But I suppose in a municipal insurance policy, I would think would probably include the entire, let's say, 50 feet. It sounds like in the situation you're describing, somebody wanted to do something private within that, and the municipality said, okay, going back to might have been your Hampton question, and the municipality may have said, fine, it's within the right of way, it's within the public road, it's in that grassy area where there's trees, we'll let you do it, but you have to insure us or indemnify us for any injury arising from what you're doing.
Okay, so now you live in Concord, or your office is in Concord.
Yes.
It's a whole bunch of sidewalks. So all the houses with the sidewalk in front of it, does their property go to the middle of the road then?
Yeah, the middle of the road presumption still applies, but sidewalks are considered part of highways, part of the municipal. So municipality could maintain the sidewalks if they wanted to. I don't think they do. And so people do. It's voluntary. I don't think they will. In fact, even downtown on Main Street, sometimes actually downtown, everybody, it's all plowed. But when you get outside of downtown, sometimes it's people don't shovel the sidewalks.
Okay, so the town doesn't do that really, and you're required to as the homeowner, or that's gray area?
Gray area.
Okay, interesting. Yeah, because land is, in terms of other states require to have a survey. We don't in real estate have a survey. Some lenders may require it, but it's not like a full-fledged survey. That's where I think you probably get busy with people when they don't have actual surveys to show exactly where a lot is. And I would predict. Now, do you deal with people who put up fences and maybe in the wrong place?
Yes, we do.
In general, what I've heard, may not be true, is that your fence needs to be a foot away from their lot, under the theory that if you need to work on it, you can go on the other side to fix the fence.
Yeah, there is something, I'm not sure, it's either a statute or maybe it's by ordinance. Yeah, there is something to that, because if you didn't have that, then you technically be trespassing if you wanted to go on the other side. I don't know. I don't know the answer to that. I don't know if there's because we did have a case like that just a couple of years ago. And I don't know if there's a law. I don't think there is a law, but that's a 60% answer. I think if you wanted to, you could put a fence right on the property line, or as long as it's on your property. And then, yeah, the issue would be if you want to maintain the other side, you want to paint the other side, you got to get the consent of your neighbor. But I'm not, because I could see all sorts of problems if there was a law that required it to be a foot off. Because right now, fences are important evidence, particularly older cases where we're trying to figure out who owns what and whether there's an adverse possession claim. A fence is a classic example of someone exclusively claiming to own something, and it's right up to the fence. There's no little grace area that's included. But the issue is well taken. Without that clearance, I don't know. I would probably tell someone to put the fence right on the property line. Otherwise,
As long as it does go on the property line, because
right.
Fences sometimes make the best neighbors, I've heard.
Yeah.
It could also make a mess. So it's,
Yeah.
especially because then the fence company, are they liable? Make sure it's on the right place, and that's can get ugly. I heard of a case of somebody in Rye who put up a fence going right into the ocean. Now, of course, the ocean is tidal, and what's the determination of their property line? Is it the high water mark, whatever? But he was told he was going to be fined like $10,000 a day or something like that, because in essence, the entire shoreline is public. He just didn't want people walking in front of his property, which is my understanding. It's the ocean, so it's tidal. But property lines, people get a little nutty in where their property lines are if you're crossing over it and that kind of stuff, and you deal a lot with that. So, is there any like really wild case that you had to deal with that was just so bizarre that?
Oh boy.
The reason I say that, I have a mug that says "I'm not the only loon in the lake." I can say with confidence there were a couple clients I could not give it to.
Okay. I'd have to think about it, and it would lead to some dead time here. But I don't want to say, because there's two sides to every story, and people, as I said at the outset, when it comes to and I get it, when it comes to the waterfront, they're particularly sensitive. And sure, from a distance, you may say, "Come on, what are you upset about? Why don't you do that?" Well, that it's not that way. You're not dealing with that person. You're not looking at it every day. There's some active things we've got now that, yeah, you would say, you got to be kidding me. But, and oftentimes the neighbor is intentionally being aggressive in a dumb little way. They know very well that this little thing that they're doing annoys you. So, all that stuff plays into it too.
I've seen a lot of in waterfront properties where there's a easement. A lot of it has to do with, and I see this in Moltenboro a lot, where it's an easement to allow your cows to go to the water. So there's this little path that is like an easement. People don't have their cows anymore. Now they have their labs. And I think you're allowed to walk to the lake. You're not supposed to sit at the beach and all that kind of stuff. People want to violate that. They bring their chairs and they sit there, but it's literally on somebody's property. And have you run into any sort of like defining what those pathways are and what the definition of a pathway is?
Yes, a lot. And by the way, Mike, I have an 11 o'clock. I do have to.
That's fine.
To break. I understood this would go to maybe 10:30 or so, but I can answer this last question. Yeah, so that's called the scope of an easement. So you've got an easement, and your example. Well, I'll give an example that relates to your example, which is because there's a case right on this point. There was an easement that was granted. This was, say, 1900, and it was an easement to allow a horse and buggy or a horse and a team or something to use this particular way. And then automobiles were invented, and the person who had the easement wanted to drive their automobile instead of a horse and buggy. Can they do that? The easement specifically says a horse. And the Supreme Court said, yeah, they can use the car. Things change. So specifically, you're talking about a cow versus a dog. That would be something a court would have to decide, but that's the sort of thing it would look at. It would be. And underlying, by the way, all easements is what the court calls the rule of reason. What is reasonable? So you look at when the easement was created, what was reasonable at that time, what was contemplated, what was the intent. And then when you bring it forward to today's world, the question is it reasonable? Is what you want to do reasonable? The flip side is for the property owner, is what they want to do reasonable. So you're talking about an access easement, for example, we see a lot, and you alluded to that, is it's the right to go to and from versus parking versus putting a chair down. That's something that's a scope issue. It's, we all agree that the easement exists, but the question is, what does it permit? It's very fact specific. It's really a case by case basis. It's how those are resolved.
Okay. Yeah. And cases will always come. Okay, Paul, thank you. What is the name of your firm again?
Alfano Law.
Alfano, because you are Paul Alfano.
And I'm Paul, but there's a group of us. There's a team of us, but I am the owner of the firm. Okay.
And I see you do tax abatements and things like that.
Yes.
So there's a lot we could talk. Oh, and just one more question. It says you've been selected to super lawyers. What is that?
I was? I didn't know that.
That's what was written to me. I'm not sure what it is.
It wasn't anything I would have sent you because I've never heard of that. I've heard of the designation, the organization that does that, but I wasn't aware that I'm a super lawyer, but I'm happy to claim the title.
Okay.
Yeah.
It doesn't say super duper. Could be super duper.
Something to shoot for.
It's a goal. Okay. It was very nice talking to you. I learned a lot. I learn something every day. And it's when I don't learn anything, then
sure.
I should go to sleep.
I'm happy to come back another time. We can talk about tax abatements, although the deadline is March 1st, so probably not this year,
right.
But maybe some other time. That's a whole nother realm that we do a lot of.
Okay, good. Thank you. You have a good day. I'll talk to you later. Bye now. Thanks. Thanks for tuning in to the Waterfront Agent Podcast. I'll be back with some more stories, tips, and expert interviews, and hopefully some humor. So make sure to subscribe, and I'll see you in the next episode.